Hello everybody, so welcome back to my English law channel, carrying on with murder and the loss of self-controlled offence, as in to reduce it to manslaughter. So say there's an objective element to this, and it relates to the law of provocation. We don't call it provocation anymore. So anyway, it's by section 54.1c. So the behaviour of the defendant must be in line with what one would expect from a normal person of that gender, of that age, with the usual amount of tolerance and self-control in that situation. So bear in mind, we're assuming the defendant is being put in an extraordinarily difficult situation, and the provoker has said something horrendously offensive. This Aaron Wilcox 2016 is a case about for this. So the court heard an appeal there. So if someone has a personality disorder or a mental disorder, is that one of the circumstances that the jury should consider when they're deciding whether the reaction was to be foreseen? Anyway, so the Court of Appeal said the trial judge in the original trial was right to say, no, this was not pertinent, and the jury should not give any consideration to that, because this defendant had a low frustration tolerance and had less self-control than most people. So what they're allowed to do is look at what would the circumstances of the defendant and how that is related to an ordinary person of the same race, faith, gender, sexual orientation, physique, life experiences and so on. As in, if he was racially insulted, would an ordinary person react in that way? Certainly believing in a certain religion, he said something foully insulting about his faith, would a normal person react in the same way? If the person was gay and was suffered horrendous homophobic taunts, would a normal person react in the same way, and so forth. So anyway, this means the defendant cannot depend upon some external element, such as a weakness in his or her character, the fact this person really has just no patience, or is hyper-aggressive, or certainly is drunk, right? Asmalash 2013 was a case about that. So people have to behave with the same level of self-control as normal people. So the defendant can't say, well, it wouldn't work if he said, well, I'm a hyper-aggressive person, so you've got to let me get away with it. Nuh-uh, that shan't operate. So diminished responsibility is the defence people should use if they think, well, they've got less self-control than ordinary people. So anyway, we were looking at objective matters, okay, not those who are very volatile and so on. So let's look at the evidence and procedure that are prescribed. So section 54.5 and 6 of the Coroners and Justice Act 2009 is about it. This is what it says. On a charge of murder, if sufficient evidence is adduced to raise an issue with respect to the defence under subsection 1, the jury must assume the defence is satisfied unless the prosecution proves beyond reasonable doubt that it is not. 6. For the purpose of subsection 5, sufficient evidence is adduced to raise an issue with respect to the defence if the evidence is adduced on which, in the opinion of the trial judge, a jury properly directed could reasonably conclude that the defence might apply. Close quotation. Note the word there was might apply. Right, as is normally the case in these defences, the burden of proof is on the prosecution, as in they have to disprove the assertions made by the defence. But this burden of proof does not operate unless the defendant cites some evidence which should lead the jury to believe that the defence is applicable here. Now, the judge will determine whether the evidence cited by the defendant is capable of being interpreted that way by the jury. It's up to the jury to decide whether they interpret it that way or not, but the judge will have to say that it's at least possible that it will be interpreted that way. The judge could therefore disallow certain evidence being cited if they said that the loss of self-control was a consequent upon inebriation, between sexual covetousness, or a partner's irritating remarks, a baby's weeping and so forth. I'm going to have to sneeze. Anyway, forgive me. So, or something like someone putting their fingers in the till from the family kitty to support a paramour, or some madcap business venture, or being accused of doing something very embarrassing. Anyway, the jury will be allowed to consider these things if if the judge says, well, there's something relevant. So the judge must look at the evidence before deciding whether it's worth putting to the jury or not. The Court of Appeal ruled on this in R against Dawes and R against Hatter and R against Bowyer. So this is not a matter of the judge's discretion, but it's a matter of judgment is either right or wrong. It's not discretionary. Anyway, as was set out in the case of Martin 2017, the Court of Appeal is reluctant to overturn the judge's decision on this because he or she originally heard the case. So we'll briefly touch on diminished responsibility. So this was started in Section 2 of the Homicide Act 1957, which reduced the number of categories of murder for which a person could be executed. So it's a bit similar to provocation. The reason we have it here is to allow the judge a certain discretion in murder cases, sentencing discretion. And this was vital because, of course, the death penalty was in force at the time. So the defence was reformulated by Section 52 of the Coroners and Justice Act 2009, and the changes were there made to streamline the system to make it a bit more relevant and logical, looking at mental abnormality, and that might be crucial to the defence. So you can try and substantiate abnormality. So that could be a key plank of the defence. So the defence is similar to the cases that were heard prior to 2009, and those are the authorities, and judges will probably rule in consonance with those pre-2009 cases. Now, this is a bit unusual because against the position on self-control, the burden of proof in this case is on the defence, not the prosecution. So the standard of proof is a civil standard, as in the balance of probabilities, not the criminal standard, which would be beyond all reasonable doubt. Okay, so Section 52 of the Coroners and Justice Act 2009 amends the Homicide Act 1957. So this is what the Coroners and Justice Act says. 1. A person, D, defendant, who kills or is a part of the killing of another, is not to be convicted of murder if the defendant was suffering from an abnormality of mental functioning which A, arose from a recognised mental condition, B, substantially impaired the defendant's ability to do one or more of the things mentioned in subsection 1A below, and C, provides an explanation for the defendant's acts and omissions in doing or being parting to the killing. 1A, those things are A, to understand the nature of the defendant's conduct, B, to form a rational judgment, C, to exercise self-control. So there's this abnormality of mental functioning, and it must be arising from a recognised mental disorder. So it must be found in some sort of psychiatric manual. So an abnormality of mental function is not set out as such, but that's how it is broadly understood. Something which objectively regarded as a serious deviation from what an ordinary person would do. Okay, so this test is imprecise, but this is about the ability to understand one's behaviour, to form rational judgments, and to control oneself. So a person who kills another because of an abnormal mental function might interpret the victim's words or actions in a way that is wrong. These are innocent behaviour or relatively not very provocative behaviour, but the defendant might see them as horrifically offensive. They might miscalculate the degree of peril they face, something like that. They might hear voices in their head telling them to kill somebody, thought projection, think their minds are being read, voices. Okay, so this abnormality of the mind might reduce or indeed remove the ability to control oneself, and that's why the defence comes in. Okay, so that's enough for the moment. We'll get on to recognised mental conditions later on. Goodbye.